Hello guys, are you there? Are you
Yes,
guys not
sir.
attending physical?
Yes, sir. Yes, sir.
Why you guys not attending physical classes?
Actually, sir, I'm sick. That's why I wanted to come today.
Where are you nowadays? Try to come physical. Okay, let's start. The fourth paper of ACCA, law. And we are studying the English law. What is the format of the paper? What will be the format of the paper? This paper is also computer-based paper. And in your paper, you will face 25 MCQs of 2 marks each. 25 MCQs of 2 marks each. And that will be 50 marks. And there will be 20 MCQs of 1 mark. Like in 2 marks MCQs, you will be having 4 options. Out of 4, either you need to click 1 option or 2 option. That will be according to the requirement. But in 1 mark MCQs, you will be having 3 options, and out of 3, you need to choose 1. So either you can get complete marks or you can get no marks. Like in 2 marks MCQs, like you need to click 2 options and you have correctly clicked the 1 option. There is no 1 mark. Either you can get complete 2 marks or there will be 0 mark. And then in section B, we will be having 5 multitask question of 6 marks. I mean, there will be a little bit scenario. And according to scenario, you have to click certain options. And there will be 5 questions of 6 marks each. I mean, these questions will be further divided into separate parts. So 50 marks from 25 2 marks MCQs. Then there will be 21 mark MCQs. And then there will be 5 6 marks multitask question, altogether 100 marks. And out of 100, you need to achieve 50% passing marks. This paper is not a big paper. There are only 12 chapters that we need to cover. Throughout the syllabus, what we need to cover 12 chapters. And after completing those 12 chapters, we will be able to attempt the paper. So let's start chapter 1. Let's start chapter 1. Well, I have prepared some slides, handwritten slides through which we will learn. But what you need to do, you need to cover the book by yourself. The main points from the book we are covering in the class. And after class, what you need to do, you need to just read the book. Everything will be understandable by reading the book because the main points we're going to cover in the class through these slides. So what is English legal system? English legal system is a system to make laws. I mean, what is the purpose of English legal system? To make laws, to define laws, not only to make or define laws, to implement laws as well. And what is law? Law is a formal mechanism of social control. It's a formal mechanism. Formal mechanism means there are different principles, there are different regulations. Those are defined by some authorities. Who are the authorities? Authorities are legislation. Legislation means parliament, law defined by parliament. And who is in the parliament? Ministers. Or some laws are defined according to custom and cultures, like the old laws have been defined according to customs and cultures. So law is a formal mechanism, mean principles, regulations defined by certain authorities of social contract. Social contract means those principles and regulations are enforced to control people. mean formal mechanism, principles, rules, regulations of social contract mean to control people in the society. This is called law. So why English legal system is there? To make laws and to implement laws. And what is a law? A formal mechanism in rules, principles, regulations of social control mean to enforce on the people to control people in the society. Let's move forward. There are different types of laws. First, just discuss what is the difference between private law and public law. Private law and public law. Private law is a law enforced between individual, mean different peoples will follow this law while dealing with each other. So private law enforced between individual, like court laws, contract law between people, family law, land law, like how we can buy, sell land, and probate intellectual property rights. These are the main concern nowadays. Like if a person have written a books, he is having copyrights, nobody can copy that. And company law means that company need to follow while managing its business, while registration in registration. So these are called private law. What is public law? Law created regarding matters relating to whole country mean that is imposed by the government over the whole country. Mean if you do not follow private law, one person can sue the other person. But if you do not follow the public law that is imposed on the whole country, the government will take action against you. In the law that is imposed by the government, that is public law, like a criminal law, constitutional law, and administrative law. So there are two types of laws, private and public. The word public is associated with government, like public limited company, mean government companies. So private law, law enforced between individuals, like dealing with each other. Contract law, family law, land law, intellectual property law, company law. And public law, where government will be involved, like criminal law, constitutional law, and administrative law. What are the main differences between criminal law and civil law? I mean, there are other two types, criminal law and civil law. Criminal law relate to conduct which state disapprove. It is a form of public law, mean government law, where government will take action. Mean if you don't follow, ultimately government will take action. And what is civil law? This is a form of private law, relate to matter between two individuals in form of private law. So criminal law is public law, civil law is private law between people. What is the purpose of defining criminal law? Enforcement of behavior as per state law, so that everybody should behave in the country according to government policies. If anybody is not behaving according to government policies, ultimately government can take action through criminal law because you are involved in criminal activities. If you're not following criminal law, this means you are involved in criminal activities. So government will take action. Police will catch you. And what is the purpose of civil law? To settle dispute between two individuals. Like family law, if there is dispute between family member, so this will be resolved through civil law. Court will decide according to civil law rather than criminal law. If two persons were managing a business on partnership and there is a dispute arises, government will resolve the case according to civil law because one party has sued the other party. Burden of proof mean who will prove that the other party is guilty. Mean if one party sue the other party. Burden of proof, who should prove that the other party is guilty? In case of criminal law, the state have to provide the proof that the other party is guilty. Mean this law will be state with ABC mean person name. Who is ABC? Who has committed a crime? Who has done something wrong? Mean who need to prove that other party is wrong? In case of criminal law, the prosecution means state government representative. While in case of civil law, there will be two parties. One will be claimant and other will be defendant. Claimant who is suing the other, he will be called claimant. And the other person who is facing a suit will be called defendant. So claimant have sue the defendant. This means claimant has to provide the evidence. He has to prove that defendant has done something wrong. So burden of proof in criminal law is on prosecution state, while in a civil law, it will be on claimant who is claiming that the other person has done something wrong. Person who seeks remedy, mean who want a solution against the dispute, against the problems. Might be this person, mean defendant has deceived the claimant and the claimant have filed a suit. So claimant want the solution, claimant want the remedy, either he has to pay the damages or he has to perform something according to the contract. So criminal and civil law, criminal law means public law that is imposed by the government over all the people in the country. And the purpose is to control behavior in the society. While civil law is a private law between individuals, and this law purpose is to settle dispute between two individuals. And burden of proof in criminal law is on the prosecution mean state. Because if anybody have done something wrong, police will catch you and then police will prove in the court, means state government police will prove in the court that this person has done something wrong. While in civil law, who need to prove that other party is wrong, mean burden of proof is on the claimant who is claiming that other person has done something unfair. Who want the solution mean remedy. Like other person have to pay me damages or other person have to perform something as per promise. Can you understand this? What are the other differences between criminal and civil law? Standard of proof. In criminal law, the court will impose on the defendant and there will be complete verification involved, mean beyond reasonable doubt. Mean if court is deciding that the person is guilty, they have to decide without any doubt. Mean they, if there is any doubt like other person have done something wrong or not wrong, so court cannot impose any fines or penalty. Mean court have to be clear 100%, yes, this person has done something wrong, then court can impose something. Mean standard of proof is beyond reasonable doubt, mean should be high standard of proof in criminal law. While in civil law, it is based on balance of probabilities, mean if there are certain chances, mean not 100% clear that the defendant has done something wrong to the claimant. If there are chances like he has done something, court will decide the case against the defendant. Mean criminal law is based on beyond reasonable doubt, mean high standard of proof is required to decide the court case. While in civil law, court case can be decided on the balance of probability, mean low standard, not high standard is required. The object of criminal law is to regulate society by threat of punishment. Mean if you will not follow the rule, you need to face the punishment, imprisonment, fines, penalties. While in civil law, object is providing financial compensation to restore the claimant position. Mean what will be the outcome of a civil law? The defendant have to pay any financial compensation to the claimant. While in case of criminal law, the defendant will face punishment decided by the court. Can you understand this? In criminal law, the case results if found guilty, who? The defendant. Accused will be imprisoned, fined. If innocent, he will be acquitted. Mean if he proved wrong, there will be imprisonment, fine, and if he is found innocent, then he will be free, mean acquitted. In case of criminal law, there are two parties involved: prosecution versus accused, also called defendant. While in case of civil law, there are two parties involved: claimant versus defendant. You cannot use the word accused in civil law. So who is filing a case? In case of criminal law, prosecution means state. And who is filing the case in case of civil law? Claimant, who is claiming that the defendant has done something wrong. So who is filing the case? They have to provide the burden of proof. And in case of criminal law, what could be the outcome? If the accused or defendant found guilty, there will be imprisonment, fine, mean punishment. And if he is found innocent, he will be acquitted, mean free. What could be the outcome of a civil law cases? Court will order defendant to pay damages, mean to pay financial compensation, or some other remedies. Remedy means solutions. What could be other solution? We will discuss later on. What is the difference between criminal and civil law? Criminal law means public law that is imposed by government. What is the purpose? To enforce behavior as per the laws. And burden of proof has to be proved by the prosecution. And the evidence required to settle the court case. And the evidence required to settle the court case must be beyond reasonable doubt. And why the criminal law is defined? So that the people who is doing wrong can be punished. And what could be the outcome of the court case? There could be imprisonment, fines if a defendant accused found guilty, or he will be free if he found innocent. While in case of civil law, what is the purpose to define civil law? To settle dispute between two individuals. Who need to prove the burden of proof? The claimant, because it is between claimant and defendant. And the standard of proof is based on balance of probability, not beyond reasonable doubts. And the object is to provide a financial compensation to the claimant. And what could be the outcome? The court will order the defendant to pay financial compensation, mean damages, or some other solution court may impose. What could be other solution? That we will discuss later on. So we have discussed the difference between private and public law, and we have discussed the difference between criminal and civil. Let's move towards important topic. How many courts are involved in English legal system? How many courts are involved in English legal system? The first court in English legal system is a county court. And county court normally hears civil claims. Civil claims mean civil law matters. And who will listen to the criminal cases? Magistrate court. But magistrate court not only hear only the criminal cases, they also hear the civil cases, but majority of the cases heard by magistrate court are of criminal nature. So these are the lowest level court. County court or magistrate court mean at first instance, the issue will be heard by the county court in case of civil laws and magistrate court in case of criminal laws. And if they have decided something, but the defendant is not happy with the decision, they can make appeal where in high court. High court is above a magistrate court and county court. If high court has decided something, but the defendant is not happy with the high court decision, they can make appeal to court of appeal. Court of appeal is higher than high court as well as magistrate and county court. And if a defendant is not happy with the court of appeal decision, they can appeal where the highest level court, that is Supreme Court. So at the top, the highest level of court is Supreme Court, that hear the matters from Court of Appeal. Court of Appeal hear the matters from High Court, and High Court hear the matter from County Court or Magistrate Court. First the matter will be heard or resolved at Magistrate Court or County Court. Then the defendant can make appeal to High Court, or he can make appeal to Court of Appeal, or he can make appeal to Supreme Court. Can you understand this? The lowest level courts are county court for civil laws, civil cases, and magistrate court for criminal as well as a civil, but majority criminal. The High Court is having three different divisions. The High Court is having three different divisions: Queen Bench Division, Chancery Division, and Family Division. Queen's Bench Division, Chancery Division, and Family Division. Family Division listen to the matter relating to family issues like marriage issues, adoption of children issues. Chancery Division listen to the matters relating to partnership cases like dispute between people, while Queen Bench Division listen to the matter relating to criminal nature. Because criminal cases can be heard in High Court through Magistrate Court, civil cases can be heard to High Court through County Court. So these are relating to civil matters, family, and other business matters, while Queen's Bench Division is mainly for criminal matter. So Magistrate Court, mainly criminal jurisdiction, though it hears both matter relating to criminal law as well as civil law, but mainly criminal. County Court hears the first instances civil claim. In civil claims matter first brought here in County Court. And in case of any large complex cases that are not resolved by Magistrate Court, that can be put forward to High Court. And Court of Appeal hears appeal from High Court and County Court. Matter can be put directly to Court of Appeal or through High Court. So that's why Court of Appeal is hearing appeals from high and county court. Obviously, if defendant is not happy with the decision of a high court, he can make appeal to court of appeal, or he can directly move towards the Supreme Court by eliminating court of appeal, the green line. And if he is eliminating one of the court, that procedure is called leapfrog procedures. There is a hierarchy. From county and state court, the matter should be brought to high court, from high court to court of appeal, and then from through court of appeal, you can move towards Supreme Court. But if you are moving towards a higher court by skipping one level of court, that will be called leapfrog procedures. County court, if you're directly putting the matter to court of appeal instead of through high court, so that will be called leapfrog procedures. In the similar manner, if a high court moving directly to Supreme Court instead of putting the matter to court of appeal, so that will be called leapfrog procedure. So can you understand this hierarchy of court? The lowest level where the matter should be heard first are magistrate court for civil and criminal, but mainly for criminal cases, county court for hearing matter of a civil nature, and large complex criminal nature cases should be brought where high court. And through high court, if you are not satisfied with the decision, you can make appeal in court of appeal. If you are not satisfied with the decision of court of appeal, you can make appeal to Supreme Court. And Supreme Court hears appeals from Court of Appeal. COA stands for Court of Appeal, and exceptionally from High Court if a matter is moving here through leapfrog procedures. And these Queen's Bench Division, Chancery Division, Family Divisions are part of which court? High Court. And all of have further appeal divisions, these are also having their own further appeal divisions. Can you understand this? Now look at, I have marked some lines with black. Through this you can move to higher courts, but by following the hierarchy. Green by skipping one court in between, you can move to higher court through leapfrog procedures. When you can move by hierarchy, black line showing appeal on question of facts. If you know the decision of this court is not properly as per the facts, they haven't heard both the parties in detail, then you can make appeal in a higher court according to hierarchy. Black line when we need to follow when there is appeal on question of facts, the facts were not clearly listened by the court. But if you are saying appeal on point of law, law was not properly followed. The policies, procedures was not properly followed while giving decision of the case, then you can move towards leapfrog procedures. So when we should adopt leapfrog procedures, we can move towards a higher court by skipping one court in case of appeal on point of law. Appeal on point of law the law was not properly considered. Rules were not properly followed by the lower court while deciding the decision. But if the facts were not properly listened, the discussion were not properly made in detail by both the parties, and court have decided the decision in a hurry, then you can move towards hierarchical order, question of facts. Can you understand? When we can move towards the upper court according to hierarchy, when there is appeal on question of facts. Question of facts mean you are not happy with the decision of this court. Why? Because they didn't allow you to explain your point of view detail. They decided the decision in hurry. Just by listening to one party, they have decided. But suppose this court haven't followed the point of law, mean they haven't followed some rules of the statute, then you can move towards a higher court without moving towards hierarchical court, mean court of appeal, mean you can adopt leapfrog procedures. So who listen to the civil matters? County court. Who listen to the criminal matters? Magistrate court. And complex criminal matters? High court. There are three divisions of high court. What are those? Queen's Bench division, Chancery division, and Family division. Who is higher to magistrate and county court? High. Who is higher to high court? Court of appeal. Who is higher to court of appeal? Supreme Court. What is a leapfrog procedures? Where you are filing appeal to higher court by skipping one of the court in the hierarchy. And it is appeal on point of law. Shall I move forward? So there is another division of criminal courts. In criminal courts, first the matter will be heard in magistrate court. From magistrate court, the matter will be brought where in crown court. From crown court, the matter will be heard in court of appeal. COA stands for court of appeal. And above court of appeal, what is that? Supreme Court. Magistrate court, crown court, court of appeal, Supreme Court mean these are what? Civil courts. County court, high court, court of appeal, and Supreme Court. Because magistrate court also hears civil claim matters, so we can say these are at the same level. But mainly county court to high court to court of appeal, and court of appeal to Supreme Court. And in case of criminal courts, instead of a high court, there is what? Crown court. So which court hears what kind of offenses? There are three types of offenses. Summary offenses. Summary offenses mean less serious offenses, like if anybody have violated the traffic rules. If anybody have violated the traffic rules, this is not a high level of offense. This is a less serious offense. So which court should resolve or hear the matter relating to summary offenses? Magistrate court. What are the other offenses? Inductible offense. Inductible offense mean trial by jury, mean very serious nature offenses like robbery and murder. And who will listen? Matter of indictable offense, not magistrate court. This should be brought into attention directly to the Crown Court. And the third offense is offense tribal either way, mean could be serious or could be summary, could be inductible. Offenses which can be tried either in magistrate or Crown Court. So who will listen to summary offenses? Magistrate court. Who will listen to indictable offenses? Crown Court. And who will listen to tribal offenses? Either magistrate or Crown. Both can listen to those matters. If any of the party is not happy with the decision of magistrate court, they can make appeal to Crown Court. If they are not happy with the decision of Crown Court, they can make appeal to Court of Appeal, Criminal Division of Court of Appeal. If you are not happy with the decision of Court of Appeal, you can make appeal to Supreme Court. Even from the state court, you can move directly to the Supreme Court. Mean you can adopt leapfrog, where in case of point of law, if you understand that the magistrate court decision is not according to the law, they haven't followed the rules properly, so you can move directly to the Supreme Court instead of moving towards Crown and Court of Appeal. But if the facts has not been clearly listened by the court, then you can follow the hierarchical order. Meaning if there is appeal on facts, then you need to follow the hierarchical order. But if there is appeal on point of law, you can adopt leapfrog. So in case of civil courts, there are hierarchical court, magistrate court, county court, then high court, then court of appeal, then Supreme Court. And high court is having three divisions: Queen's Bench Division, Chancery Division, and Family Division. In case of criminal court, there are four types of courts in a hierarchy: magistrate court, that will listen to summary offense, mean not serious offense; Crown Court, that will hear the inductible offense, mean inductible offense cannot be referred to magistrate court, they will be directly referred to Crown Court. And then from Crown Court, appeal can be made in Court of Appeal, Criminal Division. And from Court of Appeal decision, you can make appeal to higher court, means Supreme Court. From magistrate court, you can directly make appeal to Supreme Court, mean you can adopt leapfrog procedures if there is appeal on point of law. And there are three types of offenses: summary offenses, that will be heard in magistrate court; inductible offenses, that will be heard directly in Crown Court; and tribal offenses, that can be heard either in Crown or magistrate court. Can you understand this? What we have covered so far: difference between private law and public law, difference between criminal law and civil law, and English court system of civil courts and criminal courts. There are three tracking systems. Mean if there are small claims mean less than 10,000, mean where one party have a sue a claim for damages to other party for 4, 5, 6,000, mean less than 10,000. So that will be called small claims track. What is a fast track? Moderate claims mean between 10,000 to 25,000 pounds. GBP stands for Great Britain pound. The symbol for this. So less than 10,000 claims are called small claims track. 10,000 to 25,000 pound claims are moderate claims fast track. And multi-track will hear the complex and large claim of over 25,000 pound. Note, county court in case of civil deals with all small claims, majority fast track, and some multi-track claims. Mean all the small claims must be heard in county court, lower level court. Majority of the moderate claim will be heard in county court, or some you can refer to high court. And they will listen to some of the multi-track claims, but mainly multi-track claims will be heard where? In high court. What could be the other courts? European Court of Justice. As UK was part of European Court of Justice, now Europe has separated and UK has separated. Mean now this court having no effect on the English legal system. But as our book is designed, written in old days, at that time, this court was having effect on the UK, so we need to learn things accordingly. So what are the other courts? European Court of Justice. Ultimate authority on Europe. Superior to Supreme Court of UK. Mean who is a superior to Supreme Court? European Court of Justice. National level cases are heard where in European Court of Justice, in where government is involved. Government officials are. In who is above Supreme Court? European Court of Justice. European Court of Human Rights. In there are some courts that are listening matters relating to human rights. Final appeal court regarding matters related to human rights. Mean human rights matter can be finally decided where in European Court of Human Rights. There will be no appeal after the decision of European Court of Human Rights. And cases must have been executed in Supreme Court first. Means case should be heard in Supreme Court first, then it will be referred to European Court of Human Rights. Without Supreme Court, directly, no matter can be referred to European Court of Human Rights. What are the other court? Judicial Committee of Privy Council. Judicial Committee of Privy Council, highest court of appeal for number of Commonwealth countries. Who are Commonwealth countries? UK, Australia, Canada, and some other countries like in New Zealand and some other countries. I mean, there are 14 countries involved in Commonwealth. And Commonwealth countries' highest court is Judicial Committee of Privy Council. Hearing of both civil and criminal cases proceeding took place in UK Supreme Court, mean where it is residing in UK Supreme Court. The part of UK Supreme Court is Judicial Committee of Privy Council. This is the highest court of appeal for the Commonwealth countries. So who is above Supreme Court? European Court of Justice. Or European Court of Human Rights, that is relating to matter of human rights. Our Judicial Committee of Privy Council, that is relating to Commonwealth countries, the highest court of appeal. So English court system, civil courts are county court, high court, court of appeal, Supreme Court, while criminal courts are magistrate court, crown court, court of appeal, Supreme Court. There are three types of offenses: summary, inductible, tribal. And there are three types of claims: small, moderate, complex, large. And other courts are European Court of Justice, the supreme authority above the Supreme Court of UK that will listen to national level cases. European Court of Human Rights, but the matter should be heard in Supreme Court first. Judicial Committee of Privy Council, a part of Supreme Court in UK that hear the matter relating to appeal of Commonwealth countries. Other than court, the matter can be resolved through tribunal as well. Tribunal. What is tribunal? Tribunal is like a part of any organization. Like if in organization some people are having a dispute with each other, they can resolve their matter instead of moving towards a court, they can move towards tribunal. Tribunal mean a group of people who will decide the matter. Mean there will be one decider, there will be two witnesses, one from one party, one from other party, and then the decider will decide the matter according to the knowledge, skills, and experience. In tribunal are like a court, but they are not a court. They could be some organizations or could be part of your existing large organization that will resolve a matter between the employees. You can say like HR department. What is the difference between court and tribunal? The courts are not specialist in all areas. Courts are not specialist in all areas. They don't have expert knowledge about all areas, but while tribunal could be specialized regarding the matter, means the tribunal could be of IT experts, tribunal could be of finance experts, tribunal could be of human resource experts. The court process is slow because court have to hear to resolve so many matters, but the tribunal process is quicker. Might be tribunal is just hearing one issue. So they can resolve your matter, your issue quickly. Court process is expensive because you need to hire a lawyer who will speak in the court in, instead of you. While tribunal are cheaper, you don't need to hire any lawyer. You can speak by yourself in your defense. The court proceedings are according to strict rules that everybody have to follow, while tribunals are less formal and less intimidating, mean there are no strict rules that you need to follow. Mean they are a bit informal. And decision of court bound by the doctrine of judicial precedent, so make a consistent decision. Mean court sometimes decide a court case according to doctrine of judicial precedence. Precedence mean past case. If in the previous year court decided a case and now court is facing a similar case, whatever the decision was in the past, court will decide the current case accordingly. Mean deciding a current case according to similar previous cases decision, that is called doctrine of judicial precedence. Mean court sometimes decide based on doctrine of judicial precedence, mean according to past case decision, according to similar past case decision, so that court can make consistent decision, so that nobody can blame the court like in past similar case you decided this and now you are deciding that. So that's why court decide according to doctrine of judicial precedence, mean deciding the current cases according to past case decision. While tribunal, they will not decide according to past cases, they will decide according to current situations. So that's why there is a risk of making inconsistent decision relating to two similar matters. And they can provide different decision relating to two similar matters. So court are not specialized to hear all type of cases, while tribunals are specialized. Court process is slow, tribunal process is quicker. Court cost is more, tribunal cost is cheaper. Court proceedings is strict according to rules, while tribunals are less formal. And court decide according to doctrine of judicial precedence. That's why the court decision are consistent, while tribunal cannot follow doctrine of judicial precedence, so their decision could be inconsistent. Can you understand this? There are two sources of law. There are two sources of law. Mean past laws are of two types: common law and equity. In the old days, when law was defined, the law name was common law that was developed through local customs and introduced system of precedent. Mean according to past cases, they define some rules. And only remedy is damages. Solution to every case was damages, not other than damages. Damages mean financial compensation. And common law is rigid and inflexible. Whatever is decided, there is no chance of appeal. Whatever is decided, now you have to follow that. In the initial law was defined was common law that was developed through local customs, and that was a system of precedent. Precedent means according to past cases, and only the remedy solution mean outcome was damages mean financial compensation, nothing else. And this system common law was rigid and inflexible. And then as the common law was rigid and inflexible, so there was a system of equity. Mean they introduced a new law called equity. Equity mean based on fairness. Mean after certain time, they provided the right of appeal to the defendant, where defendant can make appeal in equity. According to equity, mean the decision will be decided according to equity law. What is equity law? Developed as petition by a party who felt common law was unjust. Mean if you are not happy with the common law decision, you can move towards equity law. And equity law is more flexible than common law because it's not based on precedent. Introduced new remedies rather than damages only. Other remedies like injunction and specific performance. What is injunction and specific performance? We will study later on. So in common law, there was only one remedy, that is damages mean financial compensation, mean pay the financial amount, that's fine. But in equity, there was other remedies like injunction and specific performance, not only the damages. And equity is concerned with the fairness and will not be granted. Meaning you cannot make appeal in equity if undue delay in bringing the case, if you put the case to equity too long. Like according to common law, decision was decided 2 years back. And after 2 years, you are now making appeal as per equity. So it's too late. Now equity will not resolve your issue. Whatever the common law decision, you have to follow that. Mean if you are not happy with common law, you can make appeal according to equity, but quickly. Equity will not be granted. Petitions acted unfairly. Mean if it is found you are also guilty, then equity will not be granted, mean there will be no decision according to equity. And equity will not be granted if there is no mutuality. If there is no mutuality, mean two parties are there. According to common law, your point of view was not accepted. And now you gonna put the matter through equity so that through fairness matter can be resolved. You should be able to receive damages or other remedies solution. But if suppose other party is not there, he is out of country, so you cannot claim equity. You cannot move towards equity because there is no mutuality. Mean both parties should be willing towards moving towards equity law. If one party is willing, other is not available, then equity will not be granted. Mean equity law will not decide your matter. mean through equity law, matter will be decided if there is no delay in putting the case to the equity after common law. If you who are putting to the equity is fair, is not unfair, mean not guilty, and if both parties are available in the country, in the society, in the situation, so that equity can hear both the parties. So sources of law mean there are two types of old laws, common law and equity. What we have studied so far, two types of law, private and public law. We have differentiated criminal law and civil law. What are the civil law codes, civil codes? What are the criminal codes? What are the tracking system? Mean three types of claim. Who will listen to whom? What are the other courts? European Court of Justice, European Court of Human Rights, Judicial Committee of Privy Council of Commonwealth countries, Court of Appeal. Who is a tribunal and the difference between court and tribunal? And two sources of law mean from where law can be defined, common law and equity. Let's take a small break. And after break, we will discuss the remaining part. Coming after 20 minutes. Yeah? Hey, are you people there? Are you there?
Yes, sir.
Yes, sir. Okay. So what we have covered so far, we have covered the difference between private law and public law. We have covered the difference between criminal law and civil law. And we have covered different types of civil courts, different types of criminal court, and three other courts. And we have covered the difference between court and tribunal. And we have covered the difference between common law and equity mean two sources of law. Let's move forward. In modern times, the following sources of law are following. Mean nowadays, mean previous laws was common law and equity. Nowadays, there are two types of laws that are being followed. That is case law and legislation. Case law and legislation. What is case law? Case law is a doctrine of judicial precedence. Mean court cases are decided according to part course case decisions. That is called case law. The word doctrine mean concept, judicial mean court, and precedence mean previous decision. In simple word, mean nowadays certain court cases are decided according to judicial precedent mean previous case decisions. So what is case law? System adopted by a judge of a following decision in previous cases is known as doctrine of judicial precedence. Some precedents mean decisions are binding, must be followed in later court cases, but some precedents are persuasive, mean may be followed but not bound. Means some precedents mean past case decisions are binding, mean that must be followed in a following court, similar court cases. And some are persuasive. Persuasive mean may be followed, maybe different decision can be decided. So modern time, source of law are case law, mean according to precedents, or legislation. Legislation mean law defined by the parliament. These three factors will consider when precedence is binding, means some precedents are binding, mean must be followed, and some are persuasive, mean may be followed. When a precedence must be binding, mean must be followed, there are three factors. Hierarchy of court. Hierarchy of court mean the higher level court, mean European Court of Justice, and then lower Supreme Court, then Court of Appeal, then High Court. Mean higher level court decisions are binding on lower level courts. But decision of say Court of Appeal is binding on High Court, but not binding on Supreme Court or European Court of Justice. So when the precedence is binding or persuasive, the higher level court precedence is binding on lower level courts, but not on the higher level courts. So high court decisions are bounded, not bounded its decision, but a strong persuasive authority because this is at lowest level. But high court decisions are binding on which county court or magistrate court. Court of appeal decisions bound on lower level mean high court and itself in civil cases mean decision of a court of appeals are binding on court of appeal future decisions but relating to civil cases, not relating to criminal cases. But court of appeal decisions mean precedents are binding on lower mean high court cases, similar cases. Supreme Court decisions bound or lower level mean court of appeal and high court, but not itself. Means Supreme Court can decide different decision by itself in future cases, because their precedents are not binding on itself, but are binding on Court of Appeal and High Court. And European Court of Justice precedents bind every lower court and itself as well, either criminal, either civil. So European Court of Justice and Court of Appeal decisions are binding to lower as well as on themselves. But Court of Appeal, only the civil cases are binding on itself. Otherwise, it's all prisoners are binding on lower level. So when the precedence of a court is binding on other courts, the higher level court precedence is binding on all lower level courts. There is one slide missing. There is one slide missing. Let me find the missing slide. Let me find the missing slide. There is one slide missing. Hierarchy of court, and the second factor is a ratio descendi and obiter dicta. Ratio descendi and obiter dicta mean there are three factors according to which we can decide whether the precedence of one court is binding on other court or not. First factor is hierarchy of court. Mean higher level court precedents are binding on lower level courts. And the second factor is the ratio descendi and obiter dicta. What is ratio decidendi? It's not ratio descendi, it's a decidendi and obiter dicta. Ratio decidendi mean legal reason behind the decision. Law which was applied, they are binding. Legal reason behind the decision. Mean if the legal reason behind the decision is the same in previous case and current case, then the precedence is binding. But if hypothetical situation defined by judgment for better understanding of decision, mean if the previous decision was decided according to some hypothetical situation, not according to the law predefined, not according to the law provisions, then it will be considered obiter dicta, mean persuasive. Mean when the precedence, mean past court case decision is binding on following cases, future cases. In case of ratio decidendi, ratio decidendi mean if the part court case decision was made according to the legal provisions, according to the law defined, then the decision is binding on all future similar cases. But if in the past court case, decision was made on hypothetical situation judgment rather than according to legal provisions, then the precedence is not binding on future cases, that will be considered persuasive. So when the precedence will be binding, when the precedence will be binding, first factor, hierarchy of court, mean higher court precedence decision is binding on lower courts. Second, if it is based on ratio decidendi, mean according to legal provisions, if the case was decided in the past, now it will be considered a binding. But if the past decision was not made according to legal premise mean according to obiter dicta, mean according to hypothetical situation judgment was made while making the decision, then it will be considered persuasive, mean not binding. And the third factor is material fact of the case. If the past case facts and the current case facts are similar, then the precedence will be binding. But if the current case facts are little bit different than the past case fact, then the decision precedence will be considered persuasive. So in order for precedence to be binding, what is precedence? Past case decision. What is precedence? Past case decision. We are discussing when the past case decision are binding on the future case. According to hierarchy of court, if the similar case in the past was heard by higher court, now lower court is facing the same case, they have to follow the precedence of higher court. Second, if the past case decision was based on ratio decidendi, mean according to legal premise, then the precedence is binding. But if the past case decision was based on obiter dicta, mean based on judgment, based on hypothetical persuasion, then it will be considered persuasive. And the third, material facts of the case are same, then it will be binding. If the facts of the case, both cases mean past and future or current are different, then it will be considered persuasive. So when a precedent not binding mean considered persuasive, if it is overruled by the higher court, obviously, if your decision is overruled by the high court, mean high court has changed the decision, then this precedence will not be binding on future cases or on lower courts. If one court, suppose high court made a decision, and that is considered as precedence, mean binding on lower court like county court or magistrate court. But if the high court decision is overruled, mean cancelled by the court of appeal, then the high court precedence will not be considered binding on lower courts. If it is overruled by the statute, what is statute? Law defined by the parliament. If any decision made by the high court in the past, and if parliament had defined a law against that decision, then only the statute mean law of parliament will be followed rather than the precedence of high. If precedence was made without care, if care was not taken while deciding the court decision, mean court decision was made in a hurry, then that precedence will not be binding. Can be distinguished from earlier case, mean if the facts are different, obviously the precedence will not be binding. So when the precedence will be considered binding according to three factors: hierarchy of court, ratio decidendi and obiter dicta, and material facts of the case. And when precedence is not binding other than these factors, if it is overruled by high court, if precedence is overruled by statute, if precedence was not made with care, and if the facts are different of the current and past case, then the past case decision, mean precedence, will not be considered binding. Can you understand this? What is meant by overruling, reversing, and distinguishing? Overruling when superior court turn down the decision of lower court in different cases. Like in 1950, there was a robbery case and court decided something. In 1970, there was another robbery case. And this is the precedence. In 1970, there is any other robbery case and court decide completely different decision. Mean not following the precedence of 1950. That is called overruling. But in case of different cases, mean different nature cases. What is reversing? When superior court overturn the verdict of lower court in a same case, because superior court do not follow the precedence as binding, because superior court precedence is binding on lower court, but lower court precedence mean past case decision is not binding on superior court. And if superior court is providing a different decision with the similar cases, that will be called reversing. If superior court providing a different decision in different cases, that will be called overruling. Though court case is relating to robbery, but the nature of robbery is different. That is different case. But if the nature of robbery is the same and the superior court providing a different decision rather than following the precedence, so that will be called reversing. In reversing is in similar case, past and current, while overruling in a different case. And in overruling and reversing, the superior court is providing a different decision rather than the precedence of lower court. What is distinguishing? Where judge do not follow precedence because material facts of the two cases are different. So that is called distinguishing, mean both the cases are distinguished. That's why one court is not following the precedence of previous decision. Overruling means superior court overturn the precedence decision, but in different cases, in different facts related cases. Reversing, the superior court overturn the precedence in the similar case. What is distinguishing? Where a court do not follow the precedence because the facts of the both cases are different. Obviously, you need to follow the precedence if the facts of the case are same. Let's move towards doctrine of judicial precedence is having some advantages as well as disadvantages. Mean deciding court cases as per previous court decisions is having some advantages. Through this, we can achieve consistency. Consistency means the decision is already people can predict because the similar case in previous was decided like this. So this will be decided like that only. There is a flexibility. Mean decisions can be overturned by the superior court. If you are not happy, you can make appeal to superior court and superior court can overturn the decision. And there is clarity. Mean why you are giving this decision, everybody will accept because in the past, the same case was decided like this. And they are practical and they save time. Like do not move into detail of the case. Do not waste time in listening to the matters. If the similar case was decided in the past, so you can make the same decision for the current case. So you can save time. You can move towards further case resolving rather than just focusing on one case, wasting time there. But there are some disadvantages of judicial precedents. These are complex. How complex? Because the facts are same or not. To find this, it involves some complexity. They can be rigid, mean wrong decision of past may prevail in future cases as well. If the previous judge made the wrong decision, but you have to follow the precedence because it is binding. So you will also providing the wrong decision because you have to follow the precedence. So could be rigid. And they are reactive, not proactive. Reactive means as per the situation you are resolving after occurring the crime you are resolving. You have no defined law before, because court cases can be resolved according to precedents or according to legislation. Legislation means predefined rules. In precedents, there are no predefined rules. You are checking, oh, if this type of case we resolved, whether in the past, oh yes, we resolved, okay, make same decision. So this is reactive, not proactive. And distinguishing can be subjective procedure, whether the facts are same or different, whether we need to follow the precedents or not. This is a subjective procedure, mean might not be accurately checked, might not be accurately considered sometime. So nowadays, the modern law, source of law or case law, mean according to precedents and legislation. So we have just covered the precedents. When precedents is binding, there are three factors involved. Higher court precedents are binding on lower courts when the material facts are same, and when there is ratio decidendi, mean decided according to legal provision rather than obiter dicta, mean hypothetical judgment based. And if a superior court overturning the precedents of lower court in different cases, that is called overruling. If superior court overturning the decision or precedents of lower court in similar cases, that is called reversing. And if one judge is not following the precedents due to having different material effects of both the cases, that will be called distinguishing decision. And there are some advantages of following precedents, and there are some disadvantages as well. Now, the second source of law is legislation. Legislation means any law that is defined by parliament. Who is in the parliament? Ministers. Who is in the parliament? Ministers. Who are ministers? That are selected through people like voting. So legislation is a law made by parliament. It is known as act as well. Legislation is also called law defined by parliament is called legislation or act. Legislation is of three types: new legislation, codified legislation, and consolidated legislation. Mean law made on new issues is called new legislation. What is codified? It converts case law into act. Mean precedents. If you are converting precedents into legislation, mean defining as a legal provision, so that will be called codified legislation. Mean now you are converting precedents, mean case law, into legislation. And if legislation is defined, that will be followed in every cases. Consolidated legislation, it merges small act to form new acts. Best example is a Human Right Act. How Human Right Act mean law has been defined. All the past policies, regulations relating to human laws have been combined together. And if you are combining the different regulations and make it a single law, so that will be called consolidated legislation, meaning you are consolidating different smaller rules to make it one law. So that is called consolidated legislation. Like all the policies, procedures relating to human rights have been picked from different sources and they have been listed down together to make it a human right act. So legislation is a law defined by parliament. It is also called act, and there are three types of legislation. New legislation, that is relating to new issue. Codified legislation mean converting precedents, mean case law, into act. And consolidated, merging small different act or rules into one large act like Human Right Act is consolidated legislation. And legislation falls into two categories: act of parliament Mean law act can be defined, legislation can be defined through act of parliament, mean through ministers, or delegated legislation. Delegated legislation means some expert organization help the government to define laws, where ministers are lacking those expertise because these ministers are not expert in all fields. If you need to define a law related to accountancy and you have delegated authority to any accountancy body, you can define rules. We will approve that. So that is called defining legislation through delegated legislation. Though the legislation mean law should be defined by members of parliament. But if member of parliament is lacking some skills, so they can ask some skilled people who are not ministers to define rules. And then parliament will approve, mean sign those policies. So that is defining law through delegated legislation. So legislation act can be defined through acts of parliament, mean rules have been defined by ministers, or minister can delegate their authority to some specialist. So what is act of parliament? In act of parliament, mean law defining through parliament, there are three bodies involved. One is called House of Commons. Above to House of Commons, there is a House of Lords. And above to House of Lords, there is monarch. Monarch mean previously it was Queen Elizabeth. Now it is King Charles. So king or queen, the final authority who will approve the law, that is monarch. And after monarch approval, you cannot change the law. So if you are going to define a law against any issue in the society, first the rule will be defined in House of Commons. After defining the law, House of Commons will send the law back to House of Lords. House of Lords are having more experienced ministers. And after approval of House of Lords, the final approval is sent to the monarch, mean king, queen, and king, and they will finally sign, and that law will be applicable on the society. So when you are going to define a law, legislation, what is the process of defining legislation? A bill is prepared regarding an issue. I mean, you will write down certain rules regarding an issues in order to become act, and it passes through following stages. That bill means that rules first be read, name of the bill, and prosper is read out. Proposer mean who is defining the law. Defined person who is defining the law, he will read the bill, mean rules of the law at first, where in House of Commons. Then second reading, details debate on bill is made and then voted upon, mean then the bill will be read second time and there will be voting against the law, whether it should be defined as it is or there should be any changings. And after the debate, there will be committee stage, a committee of legal experts, and MP stands for member of parliaments, mean ministers, member of parliaments, consider wording of the bill and ensure that they are professional and does not clash with other law. Mean then those rules will be presented to some legal experts, mean lawyers and member of parliaments. They will see there is no contradiction, clash with other laws of these rules, and they are professionally okay words. Then they will decide approve. And then report stage, amended bill is reported back to parliament, mean after committee stage, they will amend according to legal experts, and then bill will be back to the parliament. And then bill will be read for the last time. And for the last time, obviously, third reading will be made. And after third meeting, The bill will be sent to both houses, House of Commons, House of Lords. The bill must receive royal assent. Royal assent means monarch approval. And after monarch approval, the law is defined. So, how a legislation can be defined or act can be defined? In Parliament, the bill will be read first time by the proposer. Next, there will be second reading, and there will be debate, and there will be voting on the bill. And then bill will be sent for committee stage, and in committee, legal expert will read out will see the wording of the rules, and they will see there is no clash with other laws. And then they will recommend something, and at the report stage, the bill will be amended according to the expert comments and will be approved by the parliament. And then parliament will send to the House of Commons and House of Lord. Mean bill will be read in House of Commons and House of Lord. And after reading in House of Commons and House of Lord, the bill will be sent to monarch. Mean royal assent mean monarch approval. And after monarch mean king or queen approval, the law is finalized to implement. So what's the process? First reading, parliament. Second reading, committee stage, report stage, and then there will be final reading called third reading. There is no fourth or fifth reading. And after third reading, the both houses will approve the bill, and then monarch will approve. In how legislation can be defined, law can be defined. So act of parliament. What's the process of act of parliament? First reading, second reading, committee stage, report stage, third reading, approved by the parliament, then approved by the House of Commons, House of Lords, and royal assent mean approval by the monarch. Monarch mean king or queen, the final authority. And there is no bill that is forwarded by House of Commons or House of Lords to the monarch and monarch haven't approved. No, monarch approved all the bills that are coming through House of Commons and House of Lords. In the history, there was no overruling or overturning by the monarch. Doctrine of sovereignty of parliament. Sovereignty means supreme authority. So parliament is the supreme authority. It can make any law it wishes. However, it can't pass an act which can never be cancelled. So who is the supreme authority of defining law? The parliament. It can make any law regarding any issues. However, it cannot pass an act which can never be cancelled, mean which act is not cancelled in the past, they cannot pass, they cannot define any law against that act. Court cannot question validity of an act. Mean court have to follow the law defined by the parliament. However, they must refuse to apply an act which is against European Union law. If a law of the parliament is against the European Union law, then court can deny the act of parliament. Otherwise, court cannot deny the act of parliament. They have to follow it. If a law is defined by the parliament, mean through legislation, what are the advantages and disadvantages of legislation? It is made by public representative because who are in the parliament? Ministers are chosen by the public through voting, made with a high standard of care because there is a process, first reading, second reading, committee stage, expert are checking the wordings, then final stage, and then approved by the House of Commons, House of Lords, and then by the monarch. So that's why it's a high standard of care. And a proactive way of lawmaking mean before any issue arise in the society, you are defining the law so that people should be aware. They should avoid that from act. But there are some disadvantages, a slow and costly process because there are so many processes involved. And member of parliaments may not be technically competent, technical expert in all fields of the society. So sometimes they might define a law with some loopholes, with some weaknesses. So to overcome this weakness, there is another method of defining legislation, and that is delegated legislation. What is delegated legislation? Law made by bodies to whom parliament delegates their authorities. The body could be any expert organization or could be any local government as well. So parliament delegates its authority because parliament lack technical competence or parliament face time constraints. Mean parliament have to look at so many areas. And if there are so many issues requiring defining legislation, so they might delegate some of the issues to any expert bodies, expert authorities. The delegated bodies are following. Statutory instrument mean law made by ministers, mean they can make a group of certain ministers and they can delegate to them instead of whole parliament will define the law, certain group of minister will define the law. So that is called statutory instrument. Or they can delegate to professional bodies like technical bodies which make law related to their profession. For example, accountancy laws or engineering laws. They can delegate to any accountancy body like ACCA, or they can delegate to local bodies like by laws made by local authorities like municipal corporations, mean body government of any local province or city. Or they can delegate to orders in council making law in time of emergency in a name of monarch on advice of parliamentary members. Order in council mean making law in time of emergency in the name of monarch on advice of parliament members. RPM mean prime minister on the advice of prime minister. Monarch can define any law quickly through emergency, mean there are no stages involved. So there are two processes to defining legislation. One is through parliament and other is through delegate legislation. When parliament will delegate, when they lack technical competence or they are facing time constraints, mean time limitations. Who are the delegated bodies? Statutory instruments mean group of ministers, professional bodies, local bodies, or orders in councils. If any delegated body is defining the law, that is called enabling act. If the law is defined by parliament, that will be called act. If the law is defined by any delegated body, mean law is defined through delegated legislation, that will be called enabling act. If parliament has delegated the authority to others to define the law, parliament still having a control over the legislation. How they are controlling the legislation. So controls are made over delegated bodies so that they cannot make law against public interest. Control by court. If delegated body exceeded their authority or make law that is unfair, court has power to cancel that using judicial review. The parliament law cannot be overturned by court. But if law is defined through delegated legislation, court can overrule the law if it is unfair. Mean they have exceeded their authorities and defined the law that is unfair. Mean that law is providing benefit to certain type of people, but not providing benefit to certain other type of people. So then court can cancel that law that is defined by delegated legislation. Controlled by Parliament. Parliament has a scrutiny committee which reviews the law made by delegated body. Mean even if law is defined by delegated body, Parliament still will review that law. And some statutory instrument must be laid before Parliament for 40 days before coming into effect. Mean the law defined through delegated legislation must be approved by the Parliament, and they need to they need approval of Parliament within 40 days. Mean if they want to impose a law by 1st January of 2025, so 40 days before this date, the delegated legislation must be approved by the Parliament. How many days before? 40 days before. So how delegated legislation can be controlled? Can be controlled by court. Mean court will see if the law, mean act defined by delegated legislation body is unfair, they can cancel the law, or Parliament can cancel the law through their review. That's why the law defined by delegated legislation must be approved by the Parliament 40 days before this law coming into effect, mean going to be enforced. So there are two ways of defining legislation. One is through act of Parliament and other is through delegated legislation. There are some advantages of delegated legislation as well as some disadvantages. What are the advantages of delegated legislation? It saves time of the Parliament. Technical competent people, technical competent people make the laws. And it is a quicker process because if you have delegated to any expert body, they have focus on that law, they can define quickly. But there are some disadvantages. Criticism as being undemocratic. Democratic means law defined by ministers. If not defined by ministers, people can criticize. It is not democratic process. Volume and lack of publicity could be problem. Mean if they have defined the law that is of too big, so many rules. So their publicity might not be on time. So this could be a problem. Statutory interpretation mean if a law has been defined through legislation, means certain rules have been written into the law, court judges have to follow those rules. How judge interpret those rules? So judge can interpret those rules according to different rules. Mean there are different rules of interpretation of law. Mean how judge while making a decision interpret the provisions of the law. Interpret me, interpret me, understand those provisions of the law. So the process by which a judge assign meaning to unclear word is known as statutory interpretation. And judges use some rules for interpretation that are, because the wording of law is bit complex. To understand the wording is bit complex, but how they understand a different wording of the rules of the provisions by following these rules. Literal rules. Literal rules mean word must be given these ordinary dictionary meaning even if it gives undesirable outcome. Mean they will check the meaning of the word in dictionary, and whatever the dictionary meaning provided by the dictionary, judge have to follow that meaning. even though the outcome of the decision are undesirable, mean unfavorable, but they have to follow the dictionary meaning of the word of law. So if they are understanding the meaning of any law word according to dictionary meaning, that will be called literal rule. That will be called literal rule. What is golden rule? When literal rule give more than one meaning, mean if dictionary providing more than one meaning against a word, they should prefer to the word, to the meaning that is more logical. Mean if the law wording is difficult to understand, mean judge cannot understand the wording. So if they are taking understanding through dictionary meaning, so that will be called literal rule. But if dictionary meaning are so many, so whatever is the logical meaning they should follow, that is called golden rule. In according to dictionary meaning, but if there are more than one meaning, they have to follow the logical meaning. What is mischief rule? Court of law interpret law by considering the issue which was started by the law. Mean why this law was defined? What was the issue? And according to that issue, they are interpreting the wording of the law that is called mischief rule. Rather than moving towards dictionary, they are seeing, checking what was the issue behind defining this law. By considering that issue, they are interpreting the wording of the law. So that is mischief rule. So according to dictionary meaning, literal rule. According to one logical dictionary meaning, golden rule. According to issue behind the law, mischief rule. Now moving towards some other rules. Purposive rule, a wisdom generis, expressio unius exclusio alternus. Expressio unius exclusio alternus. I mean, these are 6 rules. Literal rule, dictionary meaning, golden rule, logical dictionary meaning, mischief rule according to issue. Purposive rule, law is interpreted by considering what parliament mean to achieve objective by making a law. Mean what was the objective behind defining the law? Mean why this law has been defined by the parliament? What was their objective? So according to that objective, judge are making a decision, are understanding the law. So that is purposive. According to issue, mischief. According to objective of parliament behind defining the law, purposive rule. And what is a wisdom generis? A wisdom generis. General words means some kind of thing as a specified word they follow. And to explain this, let's discuss our example. There was a law against betting, and the wording of the law was betting is prohibited in house, office, room, or other places, mean other similar places. Mean according to law, betting is prohibited. But law defines the wording betting is prohibited in house, office, room, or other places, other similar places. So what happened? Person involved himself in betting in garden area or park. And he is saying betting is allowed. It is not against the betting law. Why? Because betting law is saying betting is prohibited in house, office, room, and other places, mean indoor places. This means betting is allowed in outdoor places. And the judge have decided, okay, this person is innocent. as per the wording. And if general wording means some kind of things as specified word they follow, mean it is not clear in the wording that whether it is prohibited in outdoor areas and judge is following as is prohibited in indoor areas. So this interpretation is called a wisdom generis, mean according to the general word means that it is relating to some kind of things relating to the words only. So general words mean some kind of things as specified word they follow. So this is called a wisdom generis. Mean batting is allowed in garden or parks because law is saying the general words. What are general words? Are relating to indoor areas. What is expressio unicis exclusio alternis? When states seek to establish list of what is covered by its provisions, then anything not included in this list is considered excluded. Like in a cinema, it was written no burgers and fries allowed. No burgers, comma, fries allowed. A person having a shawarma or pizza with a coke entered the cinema, and cinema people saying no, it was written these things are not allowed. But what were the things written? No burger and fried allowed, mean except burger and fried, everything is allowed. If person is entering the cinema with pizza, coke or shawarma, this means cinema cannot make a claim against that person because it is according to the expressio unius exclusio ultravius. Mean when a state seek to establish a list of what is covered, mean what is covered in the list, that is prohibited. That is not covered in the list, that are excluded from law. If law mean court deciding according to the list and the things are excluding then the list, so that will be called which rules? Expressio unius exclusio ultravius. Expresso unius exclusio Alterius ultrius. So how court or judge interpret the law? According to dictionary meaning, mean literal rule. According to most logical dictionary meaning, golden rule. And according to issue behind defining the law, mischievous rule. According to objective of parliament behind defining the law, prosperous rules. And according to general words and the same specific other words, that is a wisdom generis. And according to the inclusion of list and exclusion of list, that is expressio unius exclusio ultrius. 6 rules: literal, golden, mischief, purposive, a wisdom generis, expressio unius exclusio ultrius. There are 2, 3 small topics left, then we're gonna wind up this chapter. Presumptions, these are assumptions. Presumptions mean these are assumptions which applies unless legislation say otherwise. Meanwhile, interpreting legislation, there are some assumptions. A statute cannot conflict with international law. A statute, mean law of a country, should not conflict with international law. If it is conflicting with international law, so that will not be followed. Law does not apply retrospectively. Retrospectively means past. It will be followed prospectively. Prospectively means relating to future cases. If a law has been defined today, that law is not applicable on past cases. Past cases was decided whatever the way they were decided. The law will be followed in future cases, mean prospective effect will be there rather than retrospective effect. Retrospective mean past effect. So law will not be applied retrospectively. It will be applied prospectively. Prospectively mean future effect. Statute does not exclude jurisdiction of court. Statute does not exclude jurisdiction of court. Mean jurisdiction of court will be found. Mean in certain cases, court can overturn the statute, especially delegated legislation. Legislation does not extend beyond territorial jurisdiction of UK. Obviously, if a law is defined for a country, that will be applicable in that country only. And a statute does not alter common law. A statute cannot alter common law. Common law can be converted into legislation, but a statute mean legislation does not alter the common law. Aids to interpretation mean judges can take help to interpret the laws. And there are two types of help to interpret the law. Some are called intrinsic aids and other are called extrinsic aid, mean from where you can take help to interpret the law. Part of act mean when an act is defined, there are different parts of act, mean title of the law, objective of the law is written, preface is there, appendix mean detail of the rules are there, and side notes are there. So you can take help in interpretation of certain rules from within part of the act, that is called intrinsic aid. What are the intrinsic aid? The part of complete act. What are the part of complete act? Title, objective, preface, appendices, and side notes. You can take help from extrinsic aids, mean not part of the act. Through case law, you can interpret. Through international law, you can interpret, mean take meaning. Through constitution, you can interpret. Minutes of parliament mean the discussion of parliament, recording. Minutes mean recording of parliament discussion. Through discussion, you can find the issue, the reason, and you can interpret. And law articles, i.e. Hansard, mean different articles. Through different articles, you can take help, or you can take help through literal or golden rule, mean dictionary meaning. Mean how you can interpret the law, how you can take help to interpret the law. There are two types of help, mean aids are available: intrinsic, artifact, title, objective, preface, appendix, side notes, mean these when an act is defined, this is the part of an act. What are the extrinsic? Mean other helps other than act, case law, international law, constitution, minutes of parliament, law article mean Hansard, and dictionary. So let's move towards the last topic, Human Right Act. Human Right Act covers all the issues regarding human rights. What are the issues? Humans have a right to freedom, mean they can live freely. They can do anything. Right to express their religion, right to privacy, right to fair trial, and right of equality, mean should be treated equally. The Human Rights Act has a great impact on the existing legislation and previous precedents. They are having great impact on the existing legislation as well as previous precedents. In previous precedents, cases relating to Human Right Act, you need to follow the Human Right Act of 1998 rather than the precedents. Impact of Human Right Act. Due to Human Right Act, all new statute must be made according to Human Rights Act clause. New legislation must not be in clash with Human Rights Act. All existing legislation must be modified in accordance with the Human Rights Act because this is the newest form of legislation. Court must consider Human Rights Act in all of its decision. All old precedents that are against Human Rights Act will be considered as cancelled, mean persuasive, they will not be considered binding. If a statute is in clash with the Human Rights Act, court will issue incompatibility order. That law will be reviewed by the parliament again, and if parliament devises to change it, that law will still be valid. If any legislation that is defined by the parliament is having clash with the Human Rights Act, so court can issue order to the parliament to review your legislation again. But if parliament denies to change, parliament says no, we don't need to change this legislation is okay, then court have to follow the legislation. If there is any clash between Human Rights Act and legislation, the court first should give order to the parliament to change. If they do not change, then the law will still be valid, legislation will be valid. So chapter 1 ended. What we have covered in chapter 1, the difference between public law, private law, the difference between criminal law and civil law, courts of civil law, courts of criminal law, summary offense, inductible offense, tribal offenses, three types of claims: small, moderate, complex. European Court of Justice, European Court of Human Rights, Judicial Committee of Privy Council, Commonwealth countries. What is tribunal? The difference between court and tribunal. And sources of law: common law and equity, the old form of law. But the moderate times, the law are case law and legislation. Case law mean precedence, doctrine of judicial precedence, when the precedence will be binding and when the precedence will be persuasive. We have discussed three terms: overruling, reversing, distinguishing. Advantages of judicial precedence. Legislation is act of parliament. Three types: new, codified, consolidated. How legislation can be defined through act of parliament. First reading, second reading, committee stage, report stage, final reading, third reading, and then approved by both the House of Commons, House of Lords, and monarch. And Parliament is the supreme authority to define laws. What are the advantages of act of parliament and disadvantages? Delegated legislation, what is that? Who could be the delegated body? What are the advantages and disadvantages of delegated body? How the delegated legislation can be controlled by the court, by the parliament itself? And how court interpret the law through literal rule, golden rule, mischief rule, purposive rule, wisdom generis according to the same general meaning. Expressio unius exclusio altris mean the things that are included in the list that are not included should be considered excluded. Presumptions mean what we need to follow in statute or law. There are two types of aids to interpret the law: intrinsic and extrinsic. What is the Human Rights Act and impact of Human Rights Act? So chapter 1 is completed now. I will share these slides in a team's class material, reading material. So try to read this chapter from Kaplan book as well. Hope to see you guys in next class with something new.